I will follow on in what Mr. Láska presented about asset stripping. We, lawyers in insolvency, we know that we call these legal acts as contestable. Clawback provisions. The Slovak legislation is very similar to the Czech one, almost identical, we could say. Some acts are void if they are done during bankruptcy without approval of the administrator. These are automatically void by the law. Another group is legal acts without appropriate consideration and restricting or reducing legal acts who become void only based on court decision. What is important is the timing. The administrator can include such assets that were stripped from the company into the assets of the company based on the court decision. There are also specific examples related to restructuring proceedings. Mr. Láska mentioned several types of transactions. The most frequent transactions the courts see are transactions or transfers of assets between related persons and set-off of receivables. The Slovak Act uses a different definition of related acts. In the Czech Republic, the definition is slightly different. It's related to associates of companies. But in Slovakia, let's say it was a very wild environment, we would say. Therefore, the groups were precised more in the Slovak legislation. So, legal acts can be contested that were related to the assets of the debtor in the delay of 1 year.
Ktoré zase ja budem potom ilustrovať detailnejšie na tej judikatúre slovenských súdov.
So here you have the roughly the same as in the Czech legislation. The only difference is a legal act providing advantage to someone. There is a difference in the securing after the commitment was made. But I won't go into too much detail. Section 60, restricting legal acts, the intent of the debtor must be there, and the intent of the related person to, in fact, reduce the assets. Related persons, section 9. So, statutory bodies, members of statutory bodies, associates, other legal persons with a qualification part of 5% or more. So it's a very low threshold, and almost anyone who is somehow related to the business can fall under this category. When you come to the court, you have to prove that there are the general preconditions met, that it was a legal deed of the debtor that was in force and effective, that there was reduction of some other debtors, that there is the assets, and the administrator must know about the transaction. I will skip this because it's just summarizing more details about the contestability, so there must be a certain time delay, it must be during the default or led to default.
Tie skutkové podstaty, k tomu budem hovoriť teda neskôr, takže zase vám to len tak preletím. Môžete sa potom...
Section 59.
Vo vašom zákone je presne to isté. Platný a účinný úkon dlžníka.
No, we continue. So, a legal act in force. The court will decide that and can decide that an act was void. And a void act can be contested. In case of offsets of the counterparty, one-sided offset, such a legal act cannot be contested. The administrators would sometimes contest or file petition about a void legal act or legal act non-in-force, and in such a case the legal interest must be demonstrated. The Slovak courts do not automatically grant or agree that there is uncontestable right. The Slovak courts are requesting more, therefore the alternative petitions can lead to refusal of the claim as such, because the court might decide that there was no urgent legal need and therefore no decision is taken. Reduction of the satisfaction of creditors. There are just a few exceptions, but in general, the courts require the administrator to prove what was the value of assets just before the act and just after. So there is a group of receivables, there is this much value of assets, and the court will compare the situation before and after. The court will not analyze that you might have had the assets to satisfy your creditors, you didn't because you ended up in bankruptcy, and the court is not interested to see what you did with the money. So to illustrate, this is the regional court from Banská Bystrica who summarizes the position of the majority of Slovak courts. And I would like to note that the court in Banská Bystrica is, let's say, very used by those in default because they have a rather default-friendly approach, I would say. When preparing for this speech and going through the court decisions, I came up across a decision of the Žilina court that decided that if a debtor in default before the proceedings was satisfying only some of its creditors, some to 100%, some zero, the court in Žilina feels it is totally appropriate, and they kind of were ignoring that there exists a crime of giving advantage to one creditor. If in default or over-indebted, you have to satisfy the creditors by the same shares, and clearly the Žilina court didn't know about the respective provisions, because I found other decisions. Court in Trenčín, the district court in Trenčín, confirmed by the regional court in Trenčín. And I thought at first, they were quite reasonable, but then reading the justification, I'm not sure the judges understand the concept as such. I don't know what's the situation in Czech, but I don't think you can choose the creditor you like and you will give them more than to the others. This is a crime. Assets of the debtors. I don't know exactly what the situation is in Czech. In Slovakia, the cars, for example, something that was bought on operational leasing, these assets could not be contested. Demonstrating the default of a debtor. It's enough to demonstrate that there were two debtors with overdue claims for more than 30 days. The date of the legal act being carried out, the courts again would analyze. For example, if you do a collateral contract, it's not the date on the contract, but the date when it's inscribed into the real estate register. Section 59 says that without appropriate consideration or for lower than usual price, and there are two court decisions where the court said that if the defaulting company agreed with the client or with the contester upon some price, even though if it was 10 years ago, then this is accepted as a system without, considering whether the price has developed in the 10 years or not. So you have a contract, it's fine. Or a condition of a transfer, what we saw was that the subsequent sale must be free of charge. Again, I don't think this should be something that a court should accept. When claims are sold, then of course it's not 100% of the value, but the enforceability must be taken into account.
There are more possibilities, but the more frequent possibilities is to secure the obligation at the time when it originated. Your regulation is more precise and accurate, I would say. So we have some additional security that needs to be provided. I think the Slovak regulation is not really accurate. And then section 60, it regulates the intention of to actually reduce, to deceive the creditors, to reduce the claims of the creditors. For related persons, there is a presumption that the other party knew about the intention and needs to prove that they did not know about it. In Slovakia, you usually choose the courts where you want to file the petition. I'd like to say that the administrators, when filing the petition, do not have to pay the fee. Again, examining regarding the set-off is examining by Slovak courts very differently. Sets-off are quite frequent. You enter into a purchase agreement and then the purchase price is set off against the claim. So the courts say that nothing changes, it is a neutral act, but the courts do not think about the fact that if the purchase price was really paid as it was supposed to be, the price could be, or the amount could be used for satisfying the creditors. So if you want to do the siphoning of the funds in Slovakia, you can do it through these sets off. I also noticed that in the Czech Republic, administrators use the external law firms. The practice of Slovak courts is actually varies. It depends on individual courts. The problem is that the fees will not be paid by the counterparty, so this is something that motivates the administrator to do it efficiently. You can see that in Slovakia we still need to change some of the regulations because some sections are not actually detailed enough. Thank you for your attention, and I hope it is not the last time we see each other.